Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome, everybody, to another episode of our Curious Amalgam. I'm Sergei Zaslavsky, and the title of today's episode is Are We Thinking About Innovation the Right Way? The Role of Dynamic Efficiency in Competition Policy. When people talk about competitive effects in antitrust, the conversation usually starts with price and output. Innovation gets mentioned sometimes, but rarely gets star billing. Yet in the long term, innovation almost certainly plays a bigger role in economic growth than short-term price effects. And the relationship between competition and innovation may be more nuanced and controversial than you may think. Joining me today to explore this fascinating topic is Sarah Zhang. Hi, Sarah.
Hi.
Sarah, who's our guest today?
So our guest today is Mr. Aurelien Portuese, and he is the director of the Schumpeter Project on competition policy at the Information Technology and Innovation Foundation. So the Schumpeter Project advances a dynamic framework for competition policy in which innovation is a central concern for antitrust enforcement, not a secondary consideration. And he is also an adjunct professor of law at the Global Antitrust Institute of George Mason University and at the Catholic University of Paris. Hi, Aurelien. Thank you so much for joining us today.
Hi, Sarah. Hi, Sergei. Thanks for having me. It's a pleasure.
So what is the concept of dynamic efficiency and how does it fit into the current debate about antitrust policy?
Right. That's a very good question to start with. The concept of dynamic efficiency, of course, refers to the notion of dynamic competition and competition over time. But more specifically, the concept of dynamic efficiency can be better understood when we look at the general three types of efficiencies that economists refer to. The first one is productive efficiency, like how productive employees or firms can be, right? That's the ratio between input and output. You want firms to be very productive in order to create efficiency overall. Then there's the notion of allocative efficiency, how the market, through the price mechanism that Sergei just referred to, works. And you want the market, the transaction cost in the market to be minimized in order to for the allocative efficiency to be maximized itself. But then there's this third concept of efficiency, which is not so much about maximizing efficiency in the present state of the economy through productive efficiency or allocative efficiency, but it's to create the efficiency for the next generations, for the next era, for the next market to be created, or efficiency for the next equilibrium of the economy. And that, of course, refers to the innovative efforts of entrepreneurs and firms. And that is the concept of dynamic efficiency, how easy and how quick the market goes from one equilibrium to another, meaning that are we making sure that the conditions for the economy are best and are optimal in order to create the next efficiency. And that is precisely the world within which entrepreneurs and disruptors think about. But surprisingly, and perhaps unfortunately, it's not very much the way regulators think about market. And so that's where the disconnect is between the way entrepreneurs and disruptors can think about the next efficiency, the dynamic efficiency of the market, whereas perhaps regulators may want to maximize efficiency in the present day through allocative and productive efficiencies.
So, Aurelien, do you think that dynamic efficiency doesn't receive the attention it deserves from regulators? It sounds like you think that regulators are not paying enough attention to this type of efficiency. Why do you think that is?
Yeah, I think it is it's a safe. It's very safe to say that the regulators overlook dynamic efficiency, but it has always been the case. And I mean, just to the defense of the regulators, it's just also because it's much harder to measure dynamic efficiency or to have some quantifiable effect on dynamic efficiency. The easier, the more straightforward part is precisely to look at the market how it is and try to maximize their present efficiencies. So it's not surprising that dynamic efficiency hasn't received that much of attention. Having said that, there's a number of economists throughout the time, and going back from Schumpeter, who emphasized the notion of dynamism in the market. I think it's very important that regulators have this concern of having dynamic efficiency, even if it's not quantifiable, even if it doesn't fit into the models that regulators may apply. There's a need for regulatory humility in saying that even though we cannot measure dynamic efficiency, it's still the most important aspect that drives growth, innovation, and prosperity. And it may not fit into the economic models that we apply when we enforce antitrust principles, but yet we are bound to be concerned about it and to really focus on this aspect of dynamic efficiency. So there's a paradox in here where it's the most important aspect of innovation, of competition, and yet it's the most intriguing and most unquantifiable aspect of efficiency. And that explains why regulators haven't focused. It's not because of, for their defense, it's not the lack of willingness, it's the lack of quantifiable effect of dynamic efficiency.
Perhaps it would be helpful to look at some of the historical antecedents of this debate. You mentioned Schumpeter. I understand this debate goes back quite a while with Schumpeter versus Arrow and their different views on the relationship between competition and innovation and dynamic efficiency. How has the debate developed over the years, and how has the development of that debate affected the way regulators look at innovation and dynamic efficiency?
Right. Ultimately, the view of dynamic efficiency is how you see market power and your tolerance to market power. If you see market power as something that is very negative, where firms exhibiting some sort of market power reveal some inefficiency, like it reveals some allocative inefficiency, then you're prone to regulate, intervene, and diminish the extent to which firms can exert and can enjoy market power. That would be perhaps more our perspective of increasing competition in the short term by decreasing market power and by increasing the number of firms in the market. Reverse-wise, you have this aspect of dynamic efficiency, which has been, of course, emphasized by Schumpeter, who will see market power as a mean to an end. Market power has been seen as not only the reward for entrepreneurial efforts and innovation efforts, right? So you seek market power, out of patents. You want market power because you try to innovate and patent something, and this patent gives you some sort of market power somehow. So market power is the reward of an innovation, of innovative idea, but also is the driver of the future innovation, of the future efficiencies. It's because you have market power and because you legitimately expect future market power that you keep innovating and you keep competing against other competitors. So whether you see market power as something where it is an unsaleable market power where firms are entrenched and they will never be outcompeted by rivals, or you see market power as something very transitory, something that is very unstable in a dynamic framework, then you'll have completely different antitrust implications. The former will be closer to Arrow's perspective of decreasing market power because market power is create entrenched market position. And the latter will be more closer to the Schumpeter insight, where market power is a mean to an end and is itself very fragile. So I think it's beyond the size of the firms, beyond the question of scale of the firms. The main question is about market power. What's our tolerance to market power, and why should we tackle or have a very aggressive enforcement actions against market power without anti-competitive conduct? The main question is market power bad itself? And I think antitrust may not be toward that direction, or at least I would argue that it shouldn't be leading to a conclusion that says market power itself is bad.
So I think you've hit on something that seems kind of the key distinction between the Schumpeter school and the Arrow school. Is market power bad or not? And I think a lot of times people who do antitrust assume market power is always bad. Mm-hmm. And it sounds like if you focus on dynamic efficiency, you take the position, well, market power isn't necessarily bad. Yeah. So does that kind of flip traditional antitrust on its head, or do you still see some forms of market power that are bad and others that are beneficial? And if so, how do you differentiate between the quote-unquote bad market power versus the beneficial forms of market power?
I think you sum up the question very well. It's all the question of how you see market power. Market power as such is not and shouldn't be seen as bad per se. And as you know, of course, antitrust has moved away from per se rules. So I would advocate for an increasing role for rule of reasons and for balancing effects. So any per se rules is, I think, intellectual shortcut that doesn't bode well for critical analysis. Having said that, I think market power is not bad in itself, but it can be the result of anti-competitive behavior, and that is bad. And one example is, of course, when you gain market power or when you secure market power from cartel or collusive practices, when you clearly, from intent, but also from effect, you clearly want to diminish competition in order to collude with rivals and to extort wealth from consumers. And so that you can just basically rest on your laurels, innovate less, and of course compete less. That is a market power that has been generated from anti-competitive conduct. So just to come back to very simple, antitrust should perhaps refocus itself against the trust. It should really have an anti-trust policy where the effect of market power is overwhelmingly negative, right? The market power created by trust, created by cartels, created by collusive practice. There could be some efficiencies, but there's little overall net benefits from these practices. And unfortunately, we have completely conflated market power arising out trust in cartels with market power arising out from disruptors. You know, these garage tech firms that emerged because they were disruptors. And so they gain market power out of innovation, out of patented ideas most of the time. And now I will make very clear distinctions with market power following from cartel or collusive practice. And finally, I will make a very clear distinction as well from market power created by governments. You know, the obstacles to competitions, and we see it as part of the executive order on competition that President Biden just released last July. There were some ways to increase competition by removing government-created obstacles to competition. And we see it even recently with the baby formula shortage, when you see that there's no competition also because there's a prohibition of imports, or there's the FDA role in refraining competition is also very important. So I think market power gained from governmental restrictions or from cartels is very much different from market power generated by as a disruptor.
So I think there have been a lot of proposals for reforms flying around in recent years, and most of them seem to suggest pushing antitrust law in the opposite direction of what you suggest, to make it easier to go after unilateral conduct. What kind of reforms or changes to current policy do you think warranted to push antitrust closer to what you consider to be, the correct approach?
Yeah. So before suggesting my approach, I think it's important to understand what antitrust age we're in. We are in an age of a new antitrust populism, right? The late 19th century was characterized by a massive wave of innovations, the Gilded Age. And together with the Gilded Age, we had the kind of populist antitrust that precisely led to the birth of the main antitrust laws, right? The populist movement has led to the birth of state antitrust laws and finally federal antitrust laws. And today we are in a new age of digital disruptions, and even advocates of aggressive antitrust enforcement recognize that. Senator Klobuchar's book recognized that we are in a new digital age, and Tim Book's Cost of Business recognized that we are in a new Gilded Age. And together with the wave of disruptions, a wave of innovations, a wave of new actors that really challenged the traditional incumbents like banks or telecommunications companies or newspapers, then it's unsurprising that we have a new age of antitrust populism. So that's something historically we have to be aware that the disruptions that innovators create lead to some populist tensions where you may end up having some democratic pressure to help competitors, to help established rivals against the disruptors. So it's very important to understand that also the more aggressive antitrust enforcement that we all hear about, it's also a new way, a new type of antitrust populism that used to be the case. And that's why also you can hear calls for reinvigorating the Robinson-Patman Act. Say like firms shouldn't cut price because cutting price is somehow anti-competitive and harmed established rivals. So you see this kind of momentum where you have a new antitrust populism in disguise of aggressive antitrust enforcement. So that is something that is very important to mention. Having said that, my proposals would be to precisely kind of resist this populist antitrust, because the more there will be populist antitrust, the lower the pace of innovation will unfold, and the disruptors will be somehow encumbered by redistributive wealth transfer effect from disruptors to less innovative firms. So because of this dynamic effect of dynamic importance of antitrust, one thing is, first, do not harm when you do antitrust enforcement, and that would mean to keep antitrust as an ex post antitrust liability system. What does it mean? The main proposals want to shift antitrust from an ex post antitrust liability system to an ex ante regulatory regime. So like, it takes too much time to sue companies, it takes too much time to prosecute, so let's regulate ex ante. And I think to regulate ex ante create some sort of precautionary approach. It creates a bias in favor of status quo and against disruptions. And I think in order to ensure that we preserve the dynamism of the economy, we have to pay due respect to the evolutionary perspective of antitrust enforcement, and the best way to ensure that the evolutionary perspective of antitrust enforcement is best preserved was precisely to ensure judge-made law and to make sure that antitrust remains enforced by courts. So that's something that we shouldn't change, to ensure that antitrust is enforced by courts rather than by ex ante regulatory rules.
On the ex ante versus the ex post point, what about the argument that if you do all your enforcement ex post, it decreases the predictability for a business? It's more difficult for a business to know what practice will get challenged and what practice will not get challenged. And that in itself kind of chills business innovation and chills business willingness to try out new practices if they don't know what they will get slapped for and what they won't.
Yeah, but the counter argument to that, I totally understand that point. But first, we have more than a century of antitrust history. So most of the practice, like when you talk, for example, about the online supermarket that cut price, well, it's the same thing that we talked about 80 years ago about the chain store wars, right? So some practice have different characterizations, but they kind of the same that we've seen many decades ago. The two-sided platforms, well, we know that from banking applications. So first, we have antitrust history. And second of all, the second argument, which is perhaps the most important counter-argument to what you raised, is that ex post liability means that by default, everything is prohibited unless it's everything is legal unless it's prohibited. So by de facto, you have some sort of freedom to act and to compete. Because if you have ex ante prohibition rules, of course, the default position would be a prohibition, even if some practices may be pro-competitive. So I think it's more important to have a default positions toward the freedom of contract, toward the freedom of free enterprise, and toward all these aspects, rather than with ex ante rules where you have a default position on prohibitions. And we see that with the antitrust bills, but also we see that in Europe with the Digital Markets Act.
You mentioned antitrust bills, and there are a lot of proposals right now for new antitrust legislation. What is your view on what these bills get right or what they get wrong?
I think there's a lot of bills. That's true. They have one thing in common. They regulate by size. So they say that some practice are totally fine if you fall below a certain size threshold. And the very same practices are no longer fine if you fall into some sort of discretionary applied size threshold. And I think this regulatory threshold, is very problematic to me, because antitrust shouldn't be about just regulating by size. And by meaning size, just you have to know that we're not even talking about market share. We're not even talking about market positions. So you can be a large company without any dominant position in a specific market, and yet being prevented from doing practices that your rivals will be entitled to do. And so rather than fostering competition, I think, to me, it would create unfair competition, because competitors who would be very in a similar positions would be treated dissimilarly, and that is not fair competition. So that's why we need to treat behaviors and practices according to their anti-competitive intent and effect, not because of the company's size. And so these bills depart from the antitrust history, antitrust principles, because that's not how courts have regulated, or at least have treated companies. They've always treated companies according to their market dominance, or at least the market positions in a so-called relevant market. These bills don't even define a market, because there's no market to define. It's more about service or platforms. And I think it's such a departure from antitrust principles that either it would be very hard to enforce by courts, because courts will be very surprised by these principles and won't know how to apply them, or if they do apply, there will be massive unintended consequences, which ultimately harm innovation and consumers. When you have pro-competitive practice that help consumers and help and foster innovations, I see very little arguments to prevent such practice just because of the name of the company or just because of the size of the company. That is not fostering competition. That is just giving a leg up to smaller rivals against some perhaps too efficient competitors.
So you've just expressed your views on the current American antitrust reform bills on the table, but we know you're also an expert on European competition laws. So we were wondering if you have views about how the U.S. compares to Europe, both in terms of featuring and prioritizing innovation, and in terms of any European reforms that may be going on, that you have views on how they compare with the U.S. Measures.
Right. I think that's very important for American lawyers and scholars to look across the Atlantic, because there are more things going on across the Atlantic than perhaps in Congress in the U.S. The antitrust bills may not pass. It's not very likely that all these bills will pass. Contrary-wise, I mean, the Digital Markets Act in European Union, we know it's going to be implemented very soon, perhaps as early as next year. So the Digital Markets Act is all about regulating tech companies, at least few of them, like perhaps 10 biggest tech companies. That's a regulation from Brussels that is extremely harsh, in a sense that it will prevent a number of banal practices to be implemented by the so-called gatekeepers. So I think it's very important to understand that the rationale for the DMA was for the EU to help European firms against American tech companies, and they really wanted to help European firms and to basically regulate large American tech companies and not regulate similar European competitors. So it's very surprising to see American lawyers and economists praising the European Digital Markets Act, which is intended to harm the Silicon Valley and American tech leadership in this framework. So, I mean, you have a number of prohibitions, such as self-preferencing prohibitions, where companies will not be able to self-preference their own product and services when self-preferencing doesn't have any kind of definition. It means anything from pre-installed app to bundled services. So very, very common practices in the digital space will be prohibited under the Digital Markets Act. And one would expect American policymakers or American lawyers to push back. And again, contrary to that, you see the main policymakers of antitrust, because they are part of the so-called neo-Brandesians who praise the European aggressiveness in this sector, while they're praising this Digital Market Act against the American tech leadership. So I think at the end of the day, the Digital Market Act will be just like the GDPR for competition, the general data protection regulation, where it is a Brussels regulation that apply globally with this Brussels effect. And so in the absence of antitrust bills in the US, I think the DMA will apply also in the US de facto, just like GDPR applied de facto in the absence of a federal privacy law. So that's why it's so important for everybody to look at the Digital Markets Act. Now we've had a kind of leaked version of the DMA. We know it's going to be passed in the next few months, but I think as the discussions went on in the European Parliament and the Council of Ministers, the Digital Market Act went even more aggressively. I mean, you could have hoped that the Digital Market Act would have loosened up its obligations and prohibitions against the gatekeepers, but over the last year of institutional negotiations, we just saw an increase of the number of obligations and prohibitions included in the Digital Market Act. So it's a very aggressive piece of legislation, which ultimately threaten to break up tech companies. That is in the Digital Market Act. There's a number of prohibitions, number of obligations, and if you violate 2 or 3 times those obligations, which you may do it successively, right? These tech companies may end up being broken up in Europe with potential extraterritorial effect, of course. How can you break up major Silicon Valley tech companies in Europe, but not in the rest of the world? So I think the impact is massive, and it has been overlooked. And all this follows from a very populist, aggressive antitrust thinking that is not dedicated to innovation, or at least doesn't see innovation as a primary concern, because this regulation, the DMA, will ultimately harm innovation of these large tech companies, but also innovation within the ecosystem of those companies, and therefore will ultimately harm the consumers of those companies. And there are, as you know, millions. So I'm very kind of pessimistic about the DMA, unfortunately.
Well, on that cheerful note, I think we can transition to the part of our podcast where we talk, we get to know our guest a little bit more as a person, not just as a lawyer or a practitioner. Certainly a very interesting substantive discussion and a lot of things to watch for both in Europe and in the United States. But to ask a more personal question, Aurelien, what is something interesting about yourself that people who only know you professionally may not know?
Something that is interesting is that I perhaps practiced dance for a number of years, and that I will. Few people know, but I think if a lot of people listen to this podcast now, a lot of people will know.
What kind of dance?
Any type of dance. Any type of dance, from ballet to hip hop to any type of dance for a number of years. Yeah. So.
Wow. You still do it, or did you give it up?
Unfortunately, Antitrust take me too much time, perhaps.
Yeah. A lot of people who are lawyers have had to give up old hobbies just because it's such a time-consuming profession.
That's right.
It's very interesting. So we usually finish the podcast by playing a game called our Curious Hat, where a guest picks a number between 1 and 25. And we pull a question out of a digital hat now, used to be a physical hat, corresponding to that number. So why don't you pick a number, Aurelien?
Yeah, let's say 10.
All right. What famous living or dead person would you want to meet and why?
I will say, unsurprisingly, I would have said perhaps Joseph Schumpeter is because he was, as a person, then I'm talking as a person, he was the so-called enfant terrible, like he was outside the class of economists. He was a disruptor himself as an economist. He was not liked, and he never got a Nobel Prize. He was not very classical. He was not mainstream economist. And what I read and what I heard is that when he was teaching at Harvard University, it attracted so many students. He was like a showman, and I think that's kind of the intellectual discussions we also need, like intellectual battles against also Keynes. He had the discussions about battles against Keynes, but it was very lively. If you want, he was the opposite of Hayek. Hayek was a very quiet guy, very return, a bit sad, and I think Schumpeter must have been a great as a man, must have been a great man to meet and to encounter. He said, "I hope in life I will I will do three things: the best lover, the best lover in Vienna, the best horseman, and the best economist in the world.
In that order?
Yeah, I think in that order. And then it said I only achieved to be 2 out of the 3, and he didn't say which one. So you can guess. But it was a very funny. I mean, from the correspondences and the letters that he must have been a very funny guy, and so it gives us even more appetite to read his work and his creativity. Well,
if somebody's interested in Schumpeter as a man and also in the economics you've discussed, what is the first Schumpeter work you would recommend that they read?
I think it's the Democracy, Capitalism, Socialism, and Democracy. It's a very easily accessible book in general about capitalism, democracy, and its time. And there's just this very tiny paragraph, this tiny chapter, on monopolistic practices, and another paragraph on the power of creative destruction. So in those 2 paragraphs, you just have the whole Schumpeterian approach to competition and his idea of dynamism, precisely his idea of dynamism that he borrowed from, interestingly, from Marx, because Marx understood that capitalism was dynamic, and Marx wanted to refrain and to stop that dynamism and that dynamics, whereas Schumpeter just heralded it as a beautiful factor of capitalism. So, I think that this book will be the most important one. It was very late in his year.
Very interesting stuff, Aurelien. Thank you so much for joining us today.
Thank you.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.